and you may have something different depending on how accurate your clock is or what time zone you're in. Um, so we want to continue with the fantastic set of speakers that we have for you today. So it's my pleasure and privilege to introduce Eddie Obissi and David Grosby. Eddie is a partner with MBHB. His practice is focused on IP matters, including patent litigation, prosecution, and client counseling, particularly in the electrical and software areas. Prior to joining the firm, Mr. Obissi worked for IBM, where he advised product teams on potential legal issues stemming from the use of third-party proprietary code or open source licenses within IBM software. And Mr. Grosby is an attorney with Lee, Sullivan, Shea, and Smith. His practice is focused on IP matters as well, particularly in the electrical, mechanical, and software areas. And prior to attending law school, Mr. Grosby worked as a research assistant in the Astroparticle and Cosmic Radiation Detector Research and Development Laboratory at Florida A&M. That's quite the mouthful. So we welcome you, and we thank you so much for being with us here virtually today. We're excited for your presentation. I just want to take a second to remind everybody that at any point you should feel free to drop a comment in the chat, or if you have a question, to put it in the Q&A box, and we can get those addressed. And just as a heads up for everybody for the rest of the symposium, so after these two speakers conclude, we will have a short break, hopefully, depending on how long we run, and then we will return to Professor Cotter, and then two attorneys from McCool-Smith will present, and we'll end right around 5 o'clock Central Time, if not a little earlier. So thank you so much. We appreciate you tuning in, and Eddie and David, please take it away. Thank you.
Thanks, Roy.
Thanks, Roy. Appreciate it. So thank you again for inviting us to speak. Today we're going to be talking about damages amounts based on patent quality. And as Roy just said, my name is David Grosby. I'm an associate at the law firm of Lee, Sullivan, Shea, and Smith in Chicago. And I'll let Eddie introduce himself again.
And I am Eddie Obissi. I'm a partner at McDonald, Bainon, Hulbert, and Berghoff. And with that, let me just run through a quick agenda for our slides here in our discussion. So at the outset, we really are trying to put some limits on what the term patent quality means. Are there quantitative values that we can use to serve as an objective indicator of patent quality? Because typically, as patent attorneys, we think of these more qualitatively. We use our body of experience to evaluate quality. So can we use quantitative values to replace or supplement our own discretion? We're also going to discuss whether high quality patents would result in higher damages awards. What did our research show in that regard? And if not, I'm not going to give any spoilers yet, why they might actually result in lower damage awards. And finally, how might patent quality impact expected value of a patent in other contexts, like licensing or assignments or settlements. So with that, we'll hand it back to David.
Thanks, Eddie. So first, we want to give you a background of, the main methods that a patent is valued in today's market. And there are really three. There's the market approach, the cost approach, and the income approach. The market approach is probably the most straightforward. It's comparing a patent to similar patents to determine its value. This is seen mostly outside of the patent landscape. And I'll just use an illustrative example. If someone's trying to shop for a car, let's just say they wanted to buy a Honda Civic for whatever reason, and they see that car is listed for $40,000 or $20,000 is probably a little bit more accurate. To determine whether that car is offered at a fair price, that person might, compare that car's value with different, different dealerships or different websites, or, any of those outlets to determine whether that's a fair price. So it would make sense to be able to do that with a patent as well. However, as I'm sure everyone's aware, patents are, they are unique, and and it's very difficult to do that or to find comparable patents in the market. So since the market approach doesn't work very often, some people use the cost approach to value or place some sort of value on a patent. And the cost approach is to cost to create or replace the patent. So for example, a company that's looking to license a patent or purchase a patent might say, what is the cost of all of the research and development, the equipment, or the implementation of an equally effective technology? So let's just say that comes out to be, $1 million to develop this technology that would, replace the technology that's considered and claimed in a patent. Then using that comparison, one might opt to license or purchase this patent from the patent owner because it's of equal cost and maybe, it might be easier to implement over time. But again, there might be issues with that because, certain technology fields might not have alternative technologies. One of the biggest examples of that might be pharmaceutical technologies, right? If there is one drug that achieves a particular effect, you might not be able to replace that technology by developing a drug. And so that brings us to the last approach, which is the income approach, which is the future income flow that a patent will generate. It's a little bit harder to calculate, but if you are able to come up with a cost model that says that a patent is expected to generate, $5 million in future royalties, then one could say that that patent is worth $5 million. One problem, one glaring problem with this method is that it's difficult to calculate the future income generation because, as I'm sure people are aware, companies aren't likely to license a patent unless there's some threat of litigation or, some other catalyst or incentive for them to do so. So it's sometimes hard, and you could theorize that a certain patent would generate any range of income, and it's hard to really nail down what the future income will be. So most patent evaluators, what they'll do is they'll combine all three of these in some way, shape, or form to determine what the value of a patent should be. And this happens a lot in the damages analysis in litigations and such. But as I said, a lot of these traditional methods have problems. Each of them has their own. So what Eddie and I were curious to do is to apply patent data analytics to either supplement or provide context to these traditional valuation methods.
So like David just mentioned, we do lots of patent prosecution in our own practice, and we use analytics to justify some of the decisions that we make to clients. So if we want to file a request for continued examination, we might do that based on analytics. We might also consider analytics when we want to suggest or recommend filing a petition. And there's lots of good platforms that provide this data, and we thought it would be interested to see if we could apply them in other contexts. So some of the example metrics we would use in a prosecution context might be the allowance rate of an examiner. If an examiner is really tough, they have a low allowance rate, we might consider ways of getting away from that examiner, and there are ways to do so, maybe filing a continuation in part application, for example, for an extreme solution to that. We would also look at maybe the number of office actions or amendments to the claims that are typical of that examiner or the art unit, and see how frequently they're reversed by the PTAB. Finally, the cited references are pretty easily attainable if you look at Google Patents. Just trying to see if maybe a patent would, if it has lots of cited references, if it's more likely to be allowed rather than another, if it's cited by a lot of other patents, maybe it has some more value, more likely to be allowed. So we thought maybe we can apply these in different contexts, and specifically, we hypothesized that patent analytics for a particular patent, some of those metrics that I described earlier, might result in higher damages awards during litigation. So initial hypothesis was the higher the quality of a patent, the higher the damages award. So what we did, and this is somewhat hard to do and very subjective, is we looked at 50 different patent infringement lawsuits. We wheeled them down from I think several hundred actually, with an average of about $10 million in damages. We identified the patents that were awarded damages, and we analyzed examiners and art units associated with those patents to see if we could find any trends in some of those metrics. And Dave will go into this in a minute, but specifically we were trying to see what metrics we thought would indicate higher quality, and seeing if those higher quality patents based on those metrics would give us higher damages awards.
So while Eddie, said that we use, some of these patent data analytic metrics during prosecution to inform decisions, we chose the following metrics for our analysis based on what we thought would be most relevant to after a patent is issued, and when determining the value for litigation or the like. So the first metric we chose is the number of references cited during prosecution of the patent. And the idea for including this metric is that, it's almost logical that the more references that were considered during prosecution, the higher chance of finding validity should that patent be challenged in the future. The second metric we chose is, the number of applications citing the patent. And this number may indicate how relevant the patent is to other patents in the same field. Right. So it follows that, if the patent is, particularly long and has a lot of, good disclosure, examiners might be finding it more and more during their search when, dealing with the prosecution of a related patent in the same field. And thus it would follow that, the patent that is cited more may be more valuable. The third metric is the allowance rate of the examiner assigned to the patent. So a lower allowance rate may indicate that the examiner gives a higher level of scrutiny during prosecution of that application, which may be helpful because it may be harder for the patent owner to obtain the patent in the first place. But if the examiner gave a higher level of scrutiny, then it would follow that that patent would stand up to a validity challenge better than an examiner that is easy. And then we also included the allowance rate of the art unit assigned to the patent. And this is the reason we wanted to include, the relative allowance rate and other metrics to the art unit is to give context to how the examiner compares to the art unit, right? Because if a examiner's allowance rate is particularly low, let's say 30%, and the rest of the art unit is 70%, then that could provide us relevant data when we look at the results later, because you would need to know whether the examiner was particularly hard or that's just par for the course in the art unit, which we see during prosecution depending on the technology field. The fifth metric we looked at is the reversal rate for the examiner, which, a higher reversal rate may indicate a lower quality examiner, right? I mean, if an examiner is appealed and is overturned 80% of the time, that is not exactly what you're looking for as a patent owner, because it potentially makes the patent susceptible to a post-grant challenge later because the examiner has a bad track record. And then, likewise with the allowance rate, we also look at the reversal rate of the art unit, just because it gives context to the particular examiner's reversal rate. And then the last major metric we chose was the change in number of words for independent claims of the patent. This tends to show how many amendments were made, and on a smaller scale, the amount of estoppel that may have been created during prosecution of that particular application. And then again, to provide context, we also looked at the average change in the number of words for the independent claims within the assigned art unit. So our analysis found the following correlations for each of the metrics that we chose. And as you can see, of these metrics, only the number of references cited during prosecution had a strong positive correlation with damages awards. The other metrics appear to have little or no correlation with infringement damages. For example, being cited by several other patent applications does not strongly correlate to higher patent damages awards, since there was only a 0.201 correlation. This might be for several reasons. It might be because the patent has significant disclosure that anticipates or renders other applications obvious, and thus would appear in more searches, but has very narrow claims that cover a relatively small portion of a relative product. Do you want to go to the next slide, Eddie?
Yeah.
Thanks. So there were a few examples that stuck out to us. As Eddie said, we looked at 50 cases that had patent damages awarded, and these two seem to provide the largest, or they tended to be the largest outliers in the cases that we saw. So for example, in DSM IP assets v. Lalemand, I'm not even going to try to pronounce that. The patent owner was awarded $14.5 million in damages for the infringement. But it found that the examiner had an average allowance rate of 74%, which was 10% higher than the rest of his R unit. Although no two cases are the same, this statistic indicated that patent prosecution before this examiner yields better results on average than prosecution before a different examiner in this R unit. Further, although this examiner has a reversal rate of 66.7%, which was higher than the rest of his R unit, the jury still awarded $14.5 million in damages, right? So this was somewhat surprising to us because our hypothesis was that, you know, if an examiner has a higher average allowance rate than the rest of his R unit, that it might be shown that he's easier to get a patent with, and therefore it would be susceptible to a challenge later. But that wasn't the case in DSM IP assets. And then in contrast, the damages award in Huzu v. Nineline was only $44,000. And then looking at that examiner's statistics, the examiner that prosecuted the application only had a 42% allowance rate compared to 66% of his R unit, right? So based on our hypothesis, again, we would expect that the examiner was harder than his R unit, and therefore the patent would have a higher quality and thus yield higher patent damages because of that. However, these two outliers simply confirm aspects of our analysis of the relevant metrics. That is that it's difficult to draw a connection between patent quality and patent damages for at least the reason that a high quality patent will include narrow claims just as often than a lower quality patent would.
Yeah, so as David just mentioned, the outcome was that there was no strong correlation between some of the metrics we chose for patent quality and patent damages. And some of the reasons that might have affected our correlation values, and again, this is a pretty small sample set, 50 outcomes is not statistically viable. This was mostly a thought experiment at the outset to see, you know, should we keep going forward in this direction? But it seemed like probably not, at least with the patent damages. But some of the factors that could have affected the correlation were the technology field. If we had widely disparate art units, for example, those might just have different damages amounts for different market sizes. And like I said, market share, different patents might have widely different market share that their claims cover. So you might have an infringed claim, but it just might be for something that's not super valuable. And finally, consumer demand. Damages are based on reasonable royalty or lost profits, and those are often, you usually use some sort of objective criteria to see how much you were actually harmed by someone infringing. And so something that covers a product that's not really highly wanted, or there wasn't many units sold of the infringed product, then you might just have a lower damages award. And conversely, If you have something highly valuable that many people want, higher damages awarded. And so the quality of the patent based on those metrics might not come into play. So is this surprising? Is it surprising that patent quality doesn't necessarily correlate to patent damages? And from a sort of idealistic perspective, it is surprising. You would think that patents that are of the highest quality, that are written the best, and that were vetted the most would be the ones that generate the most patent damages. But realistically, that's not necessarily true. David mentioned this before, but claim scope is really what generates how broad a claim can cover other products and how likely it is to be infringed. And the market and the actual end product that is covered by the patent is what truly matters. So why use quality? Quality might be better suited to evaluating likelihood of validity. And because, again, damages are determined after validity is already verified by a court, maybe that's just a full stop bar to there being a connection between patent damages and the quality of the patent. One slide aside, and we can discuss this further if there's questions, but because damages are usually argued by experts on both sides, the quality of a patent might actually come into play there, where if the patent is clearly, in the opinion of the jury, of high quality and was vetted thoroughly and has very useful information and is written clearly, then maybe they'd be more likely to award damages, higher damages to the plaintiff. That's hypothetical. We do not know. And one other thing, finally, is that higher quality patents we found from just a little bit of digging seem to statistically be inversely correlated to claim breadth. And that makes sense. The longer you prosecute a patent, the more amendments you have to make, the more references you see, your claims are probably going to get narrower and narrower. And so you might have a high quality patent by our metrics, ones that are highly vetted during prosecution, but you have a patent with narrow claim scope, and that's not a guarantee that your narrow claim scope covers implementations in a valuable space. So is there hope for patent quality? Can you use it in other contexts? And the answer is theoretically yes. David and I are actually doing some further research into areas where, yeah, you can use patent quality. You can use objective metrics of patent quality to possibly have some relevance to valuation of a patent. One context that makes sense is pre-suit settlement. If you're in a context where you're discussing whether or not you want to bring suit, and the potential defendant looks at your patent and thinks it's likely valid, and the only battle there really will be is over infringement and damages, they might be more likely to settle because they don't think that they can have your patent invalidated entirely. Other scenario might be in cost estimates. If you're transferring rights in your patents, nobody wants to buy a patent that's invalid unless they're going to take maybe a non-practicing entity strategy and just trying to assert it against a lot of people and just hoping that the patent stays valid and it doesn't get challenged in front of the PTAB. And then finally, in outcomes of post-grant proceedings. So post-grant proceedings are typically looking at validity. They're not really in the business of awarding damages, but they are in the business of invalidating lots of patents. So if you have a patent that is of high quality, you might be able to have a better sense that this is likely to overcome an IPR proceeding, for example.
So this chart shows the different valuation considerations at different stages of a potential litigation and the likelihood of success, or the likelihood of metrics mattering at different stages as well. So the likelihood of validity, we can kind of start with the inner ring. The likelihood of validity has, all of the challenges that a patent could eventually face should it be challenged, right? Either subject matter eligibility, definiteness, novelty, or obviousness, as well as some other ones. So the metrics that we're looking at with respect to the allowance rate and the reversal rate would be particularly useful at this early stage, because you'd be evaluating or trying to provide any additional context you could for the value of a patent before you go to assert it, or before you reach out to, another company seeking a licensing agreement. As you begin to reach out to other companies or seek a license, the likelihood of infringement matters a lot, and that comes in with claim charts and other patent litigation tools. But at this stage, all of the metrics are still relevant, because that likelihood of validity is something that a lot of companies, as soon as they're threatened with some sort of litigation or a settlement offer of some kind, they'll go and start picking apart the patent to determine its validity. But once you get past that stage, it goes into the infringed claim coverage, which includes okay, so what of the accused infringer's products are covered by the claims? And again, this goes back to the claim charts that would go into the analysis at the assignments and licensing. But if a settlement hasn't happened at this stage, we're starting to drift more and more into the damages context, right? Which gets into the entire claim coverage and the overall market of wherever you are, right? And the market, Eddie and I found that the market is really the largest determining factor for a damages outcome, right? Which is, if you look at the new, IBM VLSI case that just came out, right? I mean, if they weren't working in that market space and that technology field, the damages amount wouldn't be as high as it, if it was compared to example, like a toy baseball bat or something like that, where sales are much lower and, production and sales volume is just lower. So it's really important to, pay attention to the different stages of a potential litigation and where, the metrics and that analysis might be most valuable. Right. And then that gets us right into this chart that shows how, at different stages of a potential patent litigation, assuming that you want to move forward with one, how the value of a patent could drop off dramatically based on findings at various stages. Right. So starting at an IPR, a post-grant proceeding, that's really, it seems to be these days, assuming one is filed against one of your patents, is the first, hurdle of where a patent's value could drop off dramatically. Because if you obtain an adverse judgment in an IPR proceeding, it can invalidate your patent and it's worthless, regardless of, whatever metrics you want to evaluate. The PTAB found your patent is invalid. But if you make it past that hurdle, the first substantive hurdle that many face in, a district court litigation is summary judgment, usually directed towards patent eligibility under Section 101. And again, a lot of patents are being invalidated at that stage from the outset, because a lot of judges don't want to deal with getting through an entire case just to find out that, it's not patent eligible and they could have disposed of it at the start. So again, you see a large drop off in patent value immediately at that stage if you get an adverse ruling. And then, a similar drop off can happen during a Markman hearing, which can happen towards the beginning, middle, or towards the end, depending on the judge's schedule in a district court litigation. But you don't see this as big of a drop off until the validity is determined. And again, if a district court judge or jury finds that the claim is invalid, then again the patent is useless. So, and then of course there's a finding of infringement. Now, while there is a value drop off for a finding of non-infringement in a district court case, that's really that drop off is relative to this particular case. that doesn't necessarily mean that the patent isn't valuable anymore. It really just depends on, who the accused infringer is and the, the products that the claims are being compared to and asserted against.
Yeah, and so finally, just to circle back to patent quality and how it might be valuable as a metric. Here is just some statistics we put together based on some sort of wide ranges of patent outcomes, and then sort of wide ranges of what we would call patent quality. Whenever you're determining the expected value of something, you multiply the likelihood of an outcome occurring and the value if that outcome was to occur. And so what we've done here is we have calculated the likelihood of a patent being valid and infringed in a litigation context, for example, or a licensing context as another example. And we've sort of juxtaposed those over these contrasting relationships. So the more likely you are to have a valid patent, and this is not always true, but statistically it seems to be true, the more likely, the less likely it is to be infringed, and vice versa. So taking those two into one metric, valid and infringed, and you multiply by a constant value term, you see that as the quality goes up on the bottom x-axis there, it does increase towards a high value, but then actually you'll see a drop off. So even though you're as high quality as you can be towards the top right, the expected value actually drops off because your likelihood of being infringed goes down. And so this chart, which we made after we decided to write our article and found our results, sort of does a good job of explaining that outcome. The fact that the highest quality patents aren't necessarily the most valuable statistically is reflected with these hypothetical numbers. And that should lead me into the final slide, which is future studies. So we have some hypothetical numbers based on some benchmarks that we've looked at, just like overall statistics of patent outcomes and overall patent quality from patents that we've sampled. But we don't know for sure if the expected value curve actually looks like this. We think it does, but we're not positive. And so our future studies would be to do further quantitative approach for determining patent quality. We can beef up some of the metrics that we used previously. We also want to try and determine claim scope in a more objective way instead of maybe just assigning a score using our own judgment. You can use some parsing techniques to determine claim breadth and claim scope. And then developing a model, and we can use machine learning or maybe just simple regression analysis to predict patent outcomes. And I think one of the promising ways of doing this might be to use something a little bit narrow, like post-grant proceedings. David was saying that might be relevant in the 102 and 103 contexts, but perhaps not in other contexts. And so we can train a model that is geared towards and focused on prior art considerations and how much patent quality plays a role in those contexts. So who knows, maybe in the next year or so, we'll have another nice article on whether or not patent quality has space in or applicability to post-grant proceedings and maybe just overall patent value, but just only directed towards the validity stage of our patent determinations. So that is it from us. We're a few minutes early, I think, but we would welcome any questions you might have about our decision-making process in our analysis and then some of the outcomes that we determined.
We can give people a few moments to type anything into the Q&A if they have anything, or into the chat. We can just wait for that. It's very possible that nothing will come up. I'm excited personally, looking forward to seeing if you guys do come out with another study. I think that there's a very interesting opportunity for data analysis in this field, especially in large numbers. I wonder if, I mean, intuitively, I don't know that there's a lot of information available just because a lot of this is confidential, but maybe bringing in like settlement values, you know, pre-damage decisions into the equation. But I imagine most of that is confidential. I don't know if you have numbers on that you can evaluate.
Yeah, I think it would be very difficult to determine with any sort of confidence. One way you might be able to do it is to survey attorneys over a broad spectrum and anonymously survey and see, you know, how many settlements they've gotten in a year and maybe like their average settlement award for different patents. But the problem is, now you have a disconnect between the patents themselves, because that reveals what case you're talking about. So if you ask some of the other factors, right, said like, you know, how many words per claim and some of those other objective criteria, and ask attorneys to do the legwork for you, maybe you could do it. But I think it'd be very tough to get someone to answer that survey.
And I think it could be really interesting, actually, reflecting back on your previous study and getting attorney input, you know, attorneys that were involved in those cases, getting their heuristic on what they thought the strength of the patent was and how it compares, which could be really cool. I don't know, I'm fascinated by this topic. So
I think that's a good point. And one way that people use models is they have human input to determine, like to confirm. So you could have your model say, this is a super high quality patent, but your attorney says, no, actually it's worthless and here's why. And your model can adjust accordingly if you're doing like a true machine learning model rather than just regression analysis.
Yeah, but I think one of the big, you know, practical takeaways is that it can, you know, an attorney can use these patent data analytic metrics to empower their decisions and empower their, you know, their settlement discussions by having some sort of objective, you know, objective data to fall back on. Because a lot of attorneys, they give it, you know, an eye test. And I used to do this, you know, when I first started practicing, is you know, you look at a patent, you're like, all right, the specification's short, the claims are short, you know, it doesn't seem particularly valuable. And while that might be good if you have, you know, a wealth of experience, I think that this could help, especially younger attorneys, have some sort of rational underpinning for, you know, what they're arguing with respect to a certain patent.
yeah, that's a great point. Okay, well, it looks